Hi everybody, and welcome back. As you can see, I've brought in my presentation indoors. Today is not anywhere near as nice a day as it was yesterday, so I thought I'd come inside and speak to you for a little while. Today about larceny, the different kinds of larcenies that you may find yourself representing a client in. And I assume that many of you have represented clients who have been charged with simple shoplifting or something more complicated like an embezzlement or an extortion or perhaps larceny by false pretense or by false promise. So there's any number of ways by which a larceny can be committed and many different theories of prosecution. But whether you're dealing with a simple shoplifting case or a complicated embezzlement or an elaborate, wide-sweeping scheme to defraud, there's always one thing that's common to every larceny and is an essential element if the prosecution is going to be able to prove the defendant guilty, and that is the element of intent. In other words, the prosecution, regardless of its theory of prosecution, must establish that the defendant intended to deprive the owner of property or to appropriate to himself or to a third person. If they don't establish intent, you don't have a successful larceny prosecution. Now, the law defines property pretty generously to include many different things, from cash to personal property to real estate to utilities, gas, electric, cable, or it can include services to which people are entitled to be compensated. For example, you may have the proverbial dine and dash, where somebody goes to a restaurant and doesn't pay for the meal because they never intended to. Or the ride and run, where somebody takes a ride on public transportation but doesn't pay the fee. Or maybe lounge and leave, where somebody spends the weekend at a hotel and stiffs on the bill, maybe pays something by check, and the person knows that the account is closed, or that there is insufficient funds in the account, and there never will be sufficient funds. So the definition of property is pretty broad sweeping. And to obtain property means simply to bring about a transfer of the property itself or a legal interest in that property. The Penal Law, Article 155, also uses the term deprive, which means to withhold property, whether it's permanently or for so long a period of time that the major part of its economic value is lost to the owner, or that it's unlikely that the property will ever be recovered. So, for example, if somebody steals your BMW or your Yugo, whatever kind of car you have, and they take it to a chop shop, there's a pretty good likelihood that you're not getting it back, at least not in one piece. And then to appropriate property means to exercise control over that property, such that, again, and under such circumstances, that the person is either never going to recover it or that its major economic value is lost. The penal law also defines owner in this way, to say that an owner is anybody who has a superior right to possession of the property that has been taken or otherwise misappropriated. So, for example, if you borrow a car from a friend or a loved one, or you rent a car from Hertz, Avis, Thrifty, or from whomever, and the car is stolen from you while it was in your custody and possession, you obviously have a superior right to possession of that car than does the thief. Now, while there may not be honor among thieves, there is certainly priority of possession. Because, believe it or not, somebody who comes into property illegally, whether it's by theft or possession of stolen property, and has it stolen from him or her, that individual has a superior right to possession to the property than the next person in line who stole it. So if you rent the car and it's stolen from you by thief number one, you have a superior right to possession over thief number one, but he in turn has a superior right to possession over thief number two. Now what about if the property in question that is stolen is illegal property, say drugs, not prescription drugs. Let's say somebody is a drug addict and they are robbed of their cash and their personal property, which in this case is cocaine. Can the thief, if caught, be prosecuted for the theft of the drugs as part of that robbery? And the answer to that is yes. Now, a jury may not have particular sympathy for this victim, but nevertheless, he had a superior right to possession of the object, in this case the cocaine that was stolen, and therefore would qualify as a victim of the robbery or the theft. Also, if his house was burglarized and the drugs were stolen from within his house, certainly the intruder could be charged with burglary and also with the theft. But once again, how sympathetic a jury would be to somebody whose contraband is stolen, I guess, would remain to be seen. Now, as I've indicated at the start, there are different kinds of larcenies. It's so many different varieties, and obviously you need to look at Article 155.05 and look at those definitions. And of course, depending on the case that you're trying, you'll want to look at the jury's instructions to see what the theory of theft is, and that of course will be contained in the accusatory instrument or the indictment. But you have, you start with the basic trespassory taking, or I think a good example of that would be shoplifting, where somebody goes into a store and steals an item that he or she has no business taking without paying for. And I'm not talking about somebody who leaves something in the cart and mistakenly walks out. There's no criminal intent there, but who shoplifts from the store. Now, if that person steals that property from the person of another, then you have a grand larceny because it's theft from the person. And if you introduce the element of force, whether actual or threatened, then that would escalate it to a robbery. And of course, if the value of the property goes up over $1,000, then you're into felony land. And then from the lower felony over $2,500 to the mid-range felonies, and if it's over $50,000, then you're dealing with Class C felony larceny. Another example can be larceny by trick, where somebody uses some type of deception or artifice in order to get somebody to turn over property, or coming into possession of property that you know has been lost or misplaced. Finders is not always keepers. Let's say, for example, somebody finds a wallet on the sidewalk, and the identifying information, license, what have you, is in there, but the person who finds it notices that there's $100 in cash, so he removes it, appropriates it to himself, and then calls the owner whose information is in the wallet, says, "Oh, Mr. So-and-so, I want you to know that I found your wallet, and I'd love to be able to return it to you." And the other person is obviously so happy, even though there's no money in it. So now we're dealing with the case of the sleazy Samaritan. But the point is that if you come into possession of property that you know has been lost or misplaced, and you know you have no right to it, and you don't take any reasonable steps to return it, then that person can be guilty of larceny. I also mentioned earlier larceny by bad check, and there's a separate charge for it, as you know, under 190.05 of the penal law. But again, to show that guilty mind or that guilty intent, you have to show that the person knew when the check was written that the account was either closed or that there were insufficient funds with no real intent to replenish them, to make good on it. Those are not easy cases to prosecute.